The federal government has assembled a coalition of allies
Amid
to
tear
denounce
gas and
states.
turmoil, hundreds of arrests in Hong Kong. 10 of them. It was brought in Wednesday.
Move, yes.
I'm grateful and emboldened by the
Country right now on a path to permanent citizenship. CBC News, Vancouver.
An aggressive and ill-considered attack.
Arbitrary detention has to stop.
Almost anyone who is arbitrarily arrested is given no reason as to why they are being held and is not shown an arrest warrant. Many, or the overwhelming majority of arbitrarily detained persons, can be kept held without charge, with their location secret from their families, friends, the general public, and open trial courts, depending on the social background. Many people who are arbitrarily detained and imprisoned are exposed to physical or psychological brutality during questioning, as well as extrajudicial punishment and other violations by those who are keeping them.
As of late, situations of arbitrary detentions in Hong Kong have gained attention on an international scale. A field investigation initiated by Amnesty International reported that an alarming number of Hong Kong nationals had been arbitrarily detained during mass protests in the country, beginning in June of 2019. Let us take a look at the situation in Hong Kong, which has led to the mass arbitrary detention of its people. Mass protests began to emerge rapidly in the country in 2019 due to proposed legislative amendments that would have allowed for extradition to mainland China. This would allow Hong Kong to deliver those accused or convicted of committing a crime in Hong Kong to China to face its legal system. The protests, also known as the Anti-Extradition Law Amendment Bill movement, were mostly peaceful. However, there has been some violence which has only been made worse by the excessive use of force by police officials. A large percentage of peaceful protesters were detained without a lawful reason and abused harshly in private. They were arrested by the police force solely due to their participation in said protests. Amnesty International also documented numerous cases in which the police denied or delayed access to lawyers and medical care to detainees. The case of arbitrary detention in Hong Kong is a clear violation of human rights. The Hong Kong police have a legitimate and lawful basis to arrest protesters who are engaging in violence or who are damaging public property. However, no person should be arrested solely for exercising rights to peaceful assembly and freedom of expression, as many of the protesters were doing. Most of the arrested people interviewed by Amnesty International were unaware that they were engaging in behavior that was considered criminal or suspicious enough to warrant their arrest.
Let's move on to Hong Kong. I heard there is a new national law for Hong Kong that had been passed and come into force last year. Is that correct?
Yes, that is true. On 30 June 2020, China's top legislature unanimously passed a new national security law for Hong Kong to come into force on the same day.
Can you elaborate how this new law has affected the human rights issues in Hong Kong?
Firstly, this new national security law is dangerously vague and broad. Virtually anything could be deemed a threat to national security under its provision, and it can apply to anyone on the planet. Most of the crimes will eventually incur maximum penalties of life imprisonment. In the name of national security, the law gives the Chinese central and Hong Kong government new expansive powers to oversee and manage schools, social organizations, media, and the internet in Hong Kong.
How about the issue of those who are being arbitrarily arrested in Hong Kong? Did they receive proper judgment for their cases?
Under the national security law, suspects could be moved to mainland China, handled within the mainland's criminal justice system, and tried under mainland law. This is the same prospect that sparked the series of large-scale protests from mid-2019. Being charged with a national security crime on the mainland can lead to arbitrary or even secret detention. Those charged might not be able to contact their families and might be left without access to lawyers of their choice.
I see. Is there anything more you want to add before we end this interview talk?
Lastly, I just want to say that this new law is risking human rights protection in Hong Kong. China's national security law has a similar provision on respect for human rights, yet this has provided little or no protection to people targeted. There are lawyers, scholars, journalists, and NGO workers who have all been convicted of national security offences simply for exercising their freedom of expression and defending human rights.
Thank you, Ms. Amira, for the information regarding to the new national security law in Hong Kong.
Malaysia's Internal Security Act, or ISA, is a preventive detention law which was initially implemented at the beginning of the 1960s as a temporary intervention to suppress communist uprising in a state of national emergency. The Act allows for detention without trial or criminal charges under limited, legally defined circumstances on the ground that a person might be likely to perform an act that is deemed to be a danger for national security. A report based on interview with family members of the ISA detainees, their lawyers, and handwritten statement of ISA detainees was released in 2005, where it documents the physical abuse, ill treatment, and humiliation of more than 25 detainees in Kamunting Detention Center. None of the detainees have been charged or tried. Former ISA detainees have testified to being subjected to severe physical and psychological torture, including allegation of physical assault, forced nudity, round-the-clock interrogation, and death threats. All these things are done in the name of national security, but rather a deliberate stumbling in the system of justice in the country. The national security interests outweigh the standards of justice in their way of thinking, and that is by itself is controversial. Ultimately, every arrest made under the ISA illustrates that prohibits the proper justice process by itself by any measure is a gross injustice. The ISA is not a sign of leadership or development. It is a sign of repression.
What makes you think the arrests made under Malaysia's International Security Act (ISA) can be regarded as arbitrary detention?
I would say that the majority of the arrestments under ISA was a form of arbitrary detention due to the fact that, firstly, it allows the authority to arrest people without any criminal charges and obstruct the right for fair trial. Secondly, the law was proven to be a tool to oppress people from expressing their views and critiques against the government. Malaysia has recorded countless of incidents of detentions of protesters, demonstrators, and even politicians. For instance, the Baling demonstration, the Lalang operation, and even during the Reformasi movement, people were arrested just because they voiced their concerns and demands.
Do you think arbitrary detention is still taking place in Malaysia today?
Alhamdulillah, thank God, the Internal Security Act has been repealed and replaced. However, arbitrary detentions are still happening in Malaysia, but with new and different justifications used by the authority.
Why do Malaysia need to reject arbitrary detention?
Well, we must reject such practice because it is a disgrace towards our constitution. Arbitrary detention violates every rights and liberties protected by the law as documented in Part 2 of the Federal Constitution.
Around the world, foreign nationals are being detained arbitrarily and used as bargaining chips in international relations. Such tactics expose citizens of all countries who travel, work, and live abroad to greater risk. Not only is this practice contrary to international law, but it undermines friendly relations between states, global cooperation, travel, and trade. Arbitrary detention violates established principles of human rights, the rule of law, and the independence of the judiciary. In Canada, the Declaration Against Arbitrary Detention in state-to-state relations was launched to save those innocent citizens that have been involved in arbitrary arrests. Canada's leadership in the fight against this practice is a natural extension of its steadfast commitment to upholding the universal human rights and the rules-based international order. Canada encourages all like-minded states to endorse the Declaration Against Arbitrary Detention in state-to-state relations to reaffirm grave concerns about the use of arbitrary arrest or detention by states to exercise leverage over foreign governments, contrary to international law. This applies equally to individuals with dual citizenship. By endorsing the declaration, states agree to stand in solidarity against arbitrary arrest, detention, or sentencing by other states seeking to exercise leverage over them. Many countries have endorsed and promoted this declaration, reaffirming their commitment to its guiding principles and recognizing that their nationals could be vulnerable to this type of treatment.
Now let us hear the situation of arbitrary detention in Canada. Ms. Christina, recently I heard that Canada has signed a declaration against arbitrary detention. Can you explain further about it?
Yes, that's true. On the 15th of February 2021, the Declaration Against Arbitrary Detention on State-to-State Relations has been launched by Canada. An amount of 59 countries all over the world has signed this declaration, including the United States and Japan. We aim to protect all citizens who live, work, and travel within these countries. We want to raise awareness by preventing many victims from being arbitrarily detained by foreign forces.
So how this declaration help in preventing it?
In the guidelines, it has been stated that this declaration calls upon all countries to put an end to harsh conditions towards the accused, to stop denying access for legal consultation, and any cruelty or brutal treatment shall be stopped immediately.
Oh, if so, is there any previous policy regarding arbitrary detention referred in order to establish this declaration?
Yes, we did refer to several principles to strengthen our theory. For instance, we refer to Article 9, Clause 1 of International Covenant on Civil and Political Rights, where it states that no one shall be deprived from his liberty except on such grounds established by law. Apart from that, we also refer to Article 9 of Universal Declaration of Human Rights. It states that no one shall be subjected to arbitrary arrest, detention, or exile.
Oh, I see. Well, I think that concluded that Canada is certain about defending people against arbitrary detention. Thank you, Ms. Christina, for sharing.
As conclusion, there are some countries that allow arbitrary detention while some others are opposed to it. Arbitrary detention is a clear violation of human rights. This is clearly stated in Article 9 of the Universal Declaration of Human Rights, in which it is stated that no one shall be subjected to arbitrary arrest, detention, or exile. Despite this, numerous countries around the world still practice arbitrary detention due to various reasons. As such, there is still a lot to be done in order to abolish arbitrary detention from society entirely.
With that, I think this is the end of our documentary about human rights issue, arbitrary detention. See you again in the next documentary.